Hi, Attorney Steve, and welcome back to another exciting episode of Copyright Watchdog. Okay, so we are talking in this video about Twitter, embedding those little Twitter photos into your blogs. Okay, the case here at point is a case out of New York called Goldman versus Breitbart et al. Okay, so without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, so as you can see here, we have the case Goldman versus Breitbart et al. What does et al mean? Anybody know? That just means you sued a lot of other parties, and you just to shorten it up, you want to make it nice and easy, so you put et al. We'll talk about that in a second. But this case has something to do with embedding Twitter photos into your blogs and into your online magazines and things like that. Now, a lot of times you go over to a website and you see somebody's Twitter post or a picture in a post, posted into somebody's blog, and you don't really think much of it. You go, that's neat. Somebody wrote a nice blog, and it has, references to a couple different tweets, and it seems kind of neat and everything. But this case deals with what if you have a photo in your online blogs or your online magazines and whatnot, and you don't have the authorization to do it. Now, let's go over here and let's talk about this. This was a case dealing with the plaintiff, Justin Goldman. Here he is. He's got a photo of Tom Brady out in the Hamptons doing it up. And so he's got a picture of Tom Brady out there. And he puts it up on his Snapchat. It goes viral. Everybody's talking about it because it has to do with I think it's had to do with basketball. It gets posted over there on Reddit. It gets posted over there on Twitter, where the picture actually gets hosted on the Twitter feed. So this is where the picture was actually hosted. Okay, after it hits on Twitter, as you know, a lot of different media pick up the sites. They like to show everybody's tweets and who's doing what and who's saying what. And so you have these other defendants. We talked about these et al. Defendants, Time, Vox, Yahoo, Boston Globe, and I think a couple others were sued. So these were the defendants because they had taken the photo and put a little embed here. You see where I have that? Embed. So embedding is essentially like HTML code that you put into your website, and it sends you back over here to Twitter. So in other words, the news media was not hosting the photo. The photo was being hosted over here, but it was embedded so that when you click on it, it sends you back here. Now, according to this case that we had from the Ninth Circuit, that's California and all those other states, Perfect 10 versus Amazon, as long as you weren't hosting the photo, you were okay. You were not a copyright infringer. But this case dealt with whether or not the embedding was actually legal, whether you're allowed to embed that photo even though you're not hosting it, you're just linking back to the original photo. So in this case, the New York district court judge, rejected the Ninth Circuit server test, what we call the server test, whether or not that photo was being hosted on the server. And the judge said, this is publicly displaying. You are publicly displaying the photo, the Tom Brady photo. You're publicly displaying it on your website. And so that is one of the exclusive rights of a copyright holder, is to publicly display the copyrighted work. And the court said, you can't do that. You can't just put that photo in there, even though it's linking back. So it rejected the Ninth Server test. It said this action violated the public display right, and a motion for summary judgment was found in favor of the plaintiff. That means the plaintiff won the case, and now it's subject to appeal. Many people think it will be appealed because it has a lot of ramifications for these news stations. So, another important part of the holding by the judge was talking about certain defenses that could apply. The judge, I think, realized that this could cause a big problem because the nature of the internet is sharing, the sharing culture of the internet. So the judge pointed out there could be some defenses, some things to think about, such as whether or not Mr. Goldman released this into the public domain when he posted it on his Snapchat, whether there was a fair use, you're just reporting the news. Sports is obviously a very popular thing. Is there a fair use defense? Is there DMC safe harbors that could be applied? Safe harbors is certain things. If you have a notice and takedown procedure, then you can take it down and not be held infringing. And also whether or not this could be deemed an innocent infringement and thus reducing the damages. Innocent infringement doesn't eliminate the damages, it just reduces them. So this is a really interesting case to think about. Now we sort of have the West Coast and the East Coast weighing in on this. The West Coast is going more for the Perfect 10 case. That's the server test. If you're hosting it on your server, you could be liable. And now we have New York saying, that embedding it, even if it's not hosted there and it's linking back, you could also be held liable. So there we have it, another split in the law. That's the way things go in the law. So we may see if this one gets settled out and what happens here. So hope you liked the video. I appreciate your feedback, your comments. If you like this, feel free to share our video on your social media networks. Attorney Steve Honor, make sure to subscribe so you can get another episode of Copyright Watchdog next time we release it. And if you need to go to our website, attorneysteve.com. Thanks a lot. Have a great day. Have a great Friday. We'll talk to you again. Take care.